Hi everyone, my name is Thiago Amparo. I studied a comparative constitutional law at the Centro University in Budapest. I was asked by Conectas and DIREITO GV to talk a bit about the challenge on comparative constitutional law. The reason why I'm talking with you today is that basically I helped editing and I also wrote a chapter in the book that you have discussing today. Basically, what I wanted to bring it to you is a very practical perspective on how we managed those challenges that I will enlist to you today. And so my talk will be a little bit informal, but the idea is that actually to bring it to you 4 basic challenges that we face when we do comparative research and how in this book we managed to challenge them. So the first challenge that we face when we do comparative research is basically to whom we are talking. So basically, who is the public target that we are discussing with. In comparative research of the kind of the book that we're discussing today, there are 3 basic groups that are involved. The first one are the courts or the judges, especially constitutional judges. In this group, we see that constitutional judges, they use comparative law, foreign law, or international law to do 3 things basically. One is to strengthen their position. So it happened once in the US Supreme Court when they struck down the sodomy law. They referred to the jurisprudence of the European Court of Human Rights as they call the wider civilization, the values that they share with the wider civilization. So basically, they were trying to strengthen their position by referring to foreign law. The second task that constitutional judges use when they refer to comparative law is to refuse, on the opposite side, to refuse the jurisprudence in the cases of other courts. So this happens quite often in the South African Constitutional Court. For instance, when they struck down the death penalty, they actually refer to India and to international civil covenant on civil and political rights in order to say that they were refusing and that the South African Constitution has a different approach. The third task that the judges actually use in order to they approach comparative constitutional law is basically to be part of a select group. So it's fancy, as we say, that several constitutional courts in Europe, they refer to the Federal Constitutional Court in Germany in order to prove that they are part of a group, a select club of well-developed constitutional courts. The second group to whom we are addressing this book is basically academics. So academics, as Professor Conrado mentioned in his chapter in the book, they use comparative constitutional law in order to provide self-understanding and mutual cooperation between academics. So basically it's to prove that they are able to talk with each other and are able to understand each other's problems and values. We try to do this in this book by bringing several contributions from high-level academics from the 3 countries in order to prove and to bring academic expertise to the book that we are looking at. The third group of people that we address in the book too is basically activists. So this book is unique also because it does not only present the perspective of judges or the perspective of academics, but also it brings the perspective of activists. So it indeed brings a very practical perspective on those issues that they are covering. Leaving this challenge, the first challenge aside, the second challenge that is very important for us to think about is how we are doing this comparative research. So basically several comparative works, academic works, they basically talk, they present one chapter related to one jurisdiction, one country, or one topic. So they don't bring exactly what we call in this book a horizontal approach to comparative constitutional law. What we try to do in this book and how we did the comparison is basically we try to bring 2 possible approaches. One, sometimes we had leading chapters with some replies from other countries. So, for instance, we had gender equality, and sexual freedom. In those cases, among others in the book, we have one leading chapter and 2 replies from other countries. So, in this sense, we actually bring engagement. We actually engage the authors with each other. The second strategy that we had is that sometimes in the book you have one single chapter which deals with several, the 3 jurisdictions, and all the issues covered under the specific right. So, for instance, we have a chapter on the right to land that adopts this approach. So the idea of this book is actually to bring a horizontal perspective over comparison, and being able and making the authors to talk with each other, and not only to write their own chapters, but also to engage with the other chapters. Of course, it's a very hard and very ambitious endeavor, but I think we succeed also in this endeavor. The third challenge that is important to mention here, besides how we do the research and why and to whom we are doing the research, is also what we are doing here. Basically, in the conclusion, we can see there are 3 things that are discussed in the book. One is the ideal of transformative constitutionalism, the idea that constitutionalism can bring a change, social change, through law. That's one of the basic contributions in terms of the ideal of the book. The second thing that the book brings, and that's one thing that I already mentioned, is the method of the book. So there's a discussion on how to make comparative constitutional law, and how to engage with the comparison between several jurisdictions. So this is also a discussion about the method, and the book brings the idea of the horizontal method of comparison. And the third one is basically the discussion of what we call in the conclusion the machinery of those 3 jurisdictions. So there's a discussion on the book, what are the potentials and the limitations of the constitutional courts in addressing social change. So within these 3 focuses, is that what we are doing in the research. And so it's very hard actually to make research with such diverse countries with some similarities. They have strong constitutional courts, they have strong constitutions themselves, but it's very hard actually to bring and put a book together that are able to cover several topics. So what we did is that we brought case studies on specific rights on the Constitution, and also in the light of the cases. And also we discuss the method of comparison research, the machinery of those countries, jurisdictions, and the courts, and also we discuss the idea of transformative constitutionalism with approach by Professor Baxi and a reply by Professor Turnus Rock. Besides the question of what we are doing here and the challenge of making such a diversity of topics to put them together, there is also when. So that's how I actually want to end our discussion here. The fourth challenge that I want to address finally is when we are doing this research. So, which is a quite unusual way to finish the challenge. But what I want to emphasize is that this book wants to bring a transformative approach to constitutional law, and it wants to bring a very practical approach to constitutional law on the basis of the cases that we studied. So this book is neither ideological or too ideal, nor is too skeptical. The book thinks that, and the authors actually largely share, of course with some difference between them, they largely share that the constitutional law can actually bring social change. So I end with the fourth challenge, which is when we are doing this research. The countries that we are discussing here, India, Brazil, and South Africa, they are increasingly more important at an international level, and also around in the circles of constitutional law. So it's very important to bring research that compares, that brings South-South comparison, such as the one that we are seeing now, not only in the areas of constitutional law, but also in foreign policy and human rights and other issues that are important. So it's a very timely publication in the sense that it's a very time to hold those countries accountable for the transformations that they promise in their constitutional documents, and to assess critically how the constitutional courts are actually being able to live up to this ideal. I would like to finish basically by saying that, as one of the authors in the book says, that we should be very careful when we are doing comparative research, because we should not only confirm who we think we already are, in the sense that we should be able to critically assess our own very strong constitutions and very strong courts, and assess critically how and whether they can bring social change. I would like finally to thank Juana and Lucia from Conectas for this opportunity of talking with you, and also I would like to thank Oscar from Getúlio Vargas Foundation, and all the authors and contributors who presented their views in the book. And I hope you actually enjoyed the reading and you use it in a practical way, the contributions that we have there. Thank you very much.
He was ill. He was with the ear problem yesterday. I'm sure he recorded several times, and in the editing, they repeated some parts. And he was supposed to be here with us today using Skype, but he's going through a surgery in the morning because he really has a problem. So he was making a huge effort to be yesterday with us to record the message. The last presentation is on the challenges of comparative constitutional research. And there are two important things that we didn't mention about the research we were comparing different legal traditions. So we had Brazil with civil law, and India and South Africa with common law regimes. So the first thing is I want to start or to ask you to address is that if there are tools or methodologies that help to solve the challenges of different legal traditions and languages. I think those two were huge problems for us, or challenges. The first thing was, okay, we needed resilient researchers able to discuss in English and write in English, and that's not a fact. You don't get those people so easily. So, because the book is in itself an invitation for comparative constitutional research in an horizontal way on a South-South dynamic, I think we need to have concrete tools to offer. So how you do that? This was an experience, but our invitation and the way to finish the debate today is how we do that. What are the tools that are available to do comparative constitutional law?
Well, I want to thank Juana and Marta for inviting me today as the only non-participant in the book, and also the representative of the North de facto in the South-South comparison.
You.
Right. So I have some prepared remarks, and then I'll take Juana's question at the end, sort of as a preemptive question. So as some of you may know, but I think many of you are unfamiliar, my name is Jed Cronky. I am the expat American professor on the faculty here at FGV. I'm trained both as a lawyer and as an anthropologist, and one of my curiosities is that my actual training before I came to work here was in China studies, right? So I'm a comparativist by training and think about many of these questions in my own work as well. On the challenges of comparative legal research, well, one of the things about comparative law and comparative lawyers is they spend almost, if not the majority of their time, talking about how to do comparative legal research. It's an old question about what comparative law is and what its value is. And one of the things I found very interesting in reading through the book is that not only is it very normatively ambitious, but it also takes this focused case study approach. So there's a lot of issues that go into any type of comparative endeavor, but by focusing on this issue-based focus, right, you reveal some of the sort of potentials for comparative legal research. So I went ahead and I admit I read the introduction and the conclusion, and I read all the chapters on gender and sexual minorities, because I think you really have this question in the book of what is being transformed, right, when you're talking about transformative constitutionalism, right? Yeah, sorry, that's the anthropologist in me. I'm adverse to PowerPoint most of the time. So are you trying to transform a previous political regime? Are you trying to transform an engagement with the emerging global economic order? Are you trying to transform a pre-existing set of cultural norms and their relationship to legal institutions? And I think here, when you look at these issues of gender and sexual minorities, you can sort of focus in more specifically on these issues of the relationship between cultural and social norms, identity politics, and the relationship between law and social change. Okay? To start, one of the things that I just want to note that's sort of great as someone predominantly ensconced in the North part of this is the fact that most comparative constitutional studies in North America and to some extent Europe are dominated now by quantitative methods, right? There's an obsession with formal coding. I was just at a conference last week that half the participants at the comparative constitutional law were political scientists who argued about modeling different constitutions, analyzing whether different clauses existed in constitutions and what the implications of those were. So it was actually great to come back and see these sort of textured, many on-the-ground sort of accounts about how constitutional change did or did not happen in these contexts. And I think one of the things that I assume most of you here are interested either as future researchers in this area or as activists yourselves is one of the things that the book does very well explicitly is doing a framework for comparative judicial reasoning, right? When it both comes to how comparative examples are used, but also how judicial reasoning operates in these different realms and what you then can learn for approaching judiciaries and making specific legal arguments, right? So in that way, they're empirical fodder, right? What can you say both about what's happening in the rest of the world that may be persuasive to a judicial figure in Brazil or for our exchange students in other countries, but also specifically outside of those sort of direct invocations of comparative examples, how do judges reason and what forms of reasoning appeal to different type of judicial positions, right? So this is what Mendel in the book called constitutional imagination, right? You, as a lawyer and a practitioner and an activist, can expand your imagination about the type of arguments that you make. Now, I wanted to push a little bit more on what sort of the implicit promise is in this type of work, right? And that is the interrelationship between law, legal argumentation, and social politics. So in the United States, we call this popular constitutionalism, which is a new sort of figure in the last 2 decades about the fact that what happens inside of courts is not the sort of entire story about social change, right? And you can even see this in the Baxi and Rowe sort of contest in the beginning of this book about, democratic politics. Oh, sorry. Democratic politics are inherently contested, right? So it's not simply that people have goals and they're trying to fight against the judiciary, but they're often interacting with other sectors of their own countries where law is one strategic tool in a larger political or social movement, right? So you see in the pieces these different narratives, right, about how change happens in each one of these countries and how they related to social movements or civil society, which many of the earlier speakers have noted, right? And the Narain piece about India, this idea of constant or continuous consultation, right? The legitimacy of the push for the legislation or the litigation in India was dependent upon an interaction with other NGOs and other social movements so that it wasn't simply an expression of the strategic imagination of the individual lawyers involved, right? This has been a key issue, I think, in a number of countries, right? Simply because you have the resources to be the one bringing cases, right? Often financial, in some terms, political, doesn't mean that necessarily you're the best person to represent in entirety the voice of these particular movements, right? And in the Ikawa piece as well, you see these different political alignments change and shift over time, right? So cases don't either exist, up until their decision, right? But they exist and then are manipulated after they're decided. I think this is important for activists, especially because most of the academic sort of literature on the origins of judicial review are decidedly cynical, right? This is mentioned earlier. Ginsburg, Herschel, these sort of dominant theories that basically judicial review was a way for elites to entrench their power or different political parties to entrench their powers, and essentially that forms of public impact litigation are appeasement at best, right? And aren't sort of geared for the type of transformative constitutionalism that most of the pieces and most of the writers here are hoping to engage in their own countries about, right? And also we see that history itself is not always unilinear, right? It's not always getting better. We just saw here in the Indian case, what was seen to be a huge step forward, right, was then shortly then a large step back. And people debate, right, about still whether these litigation strategies are good or bad, right, on an abstract level, but really these different examples led us to think about, well, what type of litigation strategies not only win, right, but have long-term durability for asserting these types of views. So the sort of idea that I came up with thinking about what, again, a young scholar or activist could sort of look at what's the use for comparative constitutionalism outside of making specific arguments, and that is this idea of comparative solidarity or comparative empathy, right? How does organizing for legal change happen in different political contexts? What is the interaction between legal and social strategies, right? One of the really interesting things for me was reading the Amparo and Narain pieces about Brazil and India and how people invoke history, a history of oppression, very differently and with very different success in different countries to get groups to have common cause, right? So for example, simply to say like, okay, in South Africa, we had a history of racial oppression, right? This was part of the revolution. This is part of our national identity. Well, when you try to invoke that history of oppression to then branch over to other groups, gender oppression, sexual minorities, it's not always an easy move, right? The United States is an example of a country where these types of moves have been very difficult to make. I think activists in Asia, right, have often said that even broad ideas of economic solidarity have had great difficulty then in translating into understanding oppression on other axes besides the economic. Also, I assume that if you're interested in these specific topics, that you have an interest in either modern feminist or queer theory. And here's one of the areas in which law and these types of strategies can not only just contribute here, but can contribute to general theorization in these fields, is if you look at the transition, right, very broadly from second to third wave feminism and some of the articulations of what people call post-feminism, right? One of these really key questions is what is solidarity and how should it operate politically, right? Once you recognize that intersectionality exists, right? The idea that race, gender, economics, and sort of come together to create diverse identities, right? How does that sort of fragmentation on a categorical level then translate into actual political movements, right? So in the Aikawa piece, she talks about in the Brazilian context how the binary, right, of gender just between male and female had a power, right, when you're trying to sort of reduce formal sort of active state discrimination, but then becomes much weaker when you're trying to sort of address these issues of intersectionality, right? Once race intersects with gender, and then once you move into sexual minorities who don't fall into that particular binary, right? We also see, and as Professor Friedman mentioned earlier, this idea of individual choice, right? And is it supposed to operate as a principle, right, or as a social reality, right? It can be highly sort of regressive, right? And this is sort of the critique of post-feminism and its relationship to legal and structural change. If everything is simply about affirming individual choice and dignity, right, what are the limitations then does that have for getting people to engage in collective action? So in the end, these different sort of ideas of the relationship between identity, social movement, and legal change really then get tied to the logics of equality that we deploy both in legal contexts and in political contexts, right? So throughout all these pieces, right, and in the sort of broader comparative view, these notions of formal versus substantive equality come up in relationship to political action in quite different ways. Right. So it gets to this sort of age-old question that activists face in many contexts of the relationship between truth and strategy, right, and short and long-term success, right? Are binary conceptualizations of gender, for example, easier for the public to digest and to move behind, and good when you're sort of litigating for formal equality, but then do they become a liability once you move towards promoting forms of positive discrimination that are trying to remedy substantive inequality? Right? And the same thing when it comes to choice, right? Choice, right, is a very powerful strategic litigation strategy in many legal systems, right? And can invoke sort of long generally sort of accepted notions of dignity, right? But then becomes very difficult when you're trying to get to structural concerns, right? So you may have a client who's able to represent these issues as a powerful narrative of the violation of their individual dignity, but is that going to be a good long-term strategy when the selection of clients becomes out of your control? So for example, many of you may be aware of the recent successes in the United States when it comes to same-sex marriage, but many, I wouldn't say many, but there is a vocal minority, some of which are my friends, so I feel necessary to point that actually disagree with the recent claims about same-sex marriage, saying that they're ultimately regressive when it comes to substantive equality for sexual minorities because it's inherently based upon formal logics and apes sort of heteronormative notions of relationships, right? I'm not necessarily saying that I agree with that, but it represents sort of a discourse where the dialogue between these notions of how you present, right, different notions of identity and social change to get litigation strategies may have both long-term effects, right, and then may have effects on your ability to maintain the same coalitions that originally prompted those victories. So I think in Professor Friedman's speech, she's quite good at showing that even in this even becomes a question for those sort of legal systems that were seen as leaders at particular points in time, right, in achieving formal equality, right? A large part of litigation strategies are simply trying to remove invidious or historical discrimination, right? Still doesn't end up then with these hard questions of how far into the private sphere, right, does this lack of formal discrimination penetrate? One of the pieces about India talked quite forthrightly about the limitations of penetrating into the private sphere to prevent even formal discrimination. But also then once you move to trying to enact policies of positive discrimination, right, this is where a lot of systems have been stuck that have been very successful in enacting or using formal logics to get rid of discrimination, right? I think the sort of case example in this case is the United States, right, has been extraordinarily successful in moving to using formalism, right, and notions of equality as a win on both gender and sexual minorities front, and now has been suffering a huge setback, right, where all sort of positive social programs to remedy racial and other forms of discrimination as it's become a bar to substantive rights. And there's a big struggle about how to get past this, right? So this is also, because we've used these formal logics and had this great deal of success, right, it's actually been a long-term liability for building social solidarity, because all the groups that could say that they were in favor of formal, getting rid of formal discrimination, now feel that the job is over, right? And that all these other forms of indirect, or what we would call structural discrimination on a variety of different axes is something that's unconstitutional, right? So this is where you get this particular stuck, where I think this whole South-South analysis, right, shows all these countries experimenting in a variety of ways with these different types of strategies that actually could potentially provide a solution to a problem that exists in the North that the North has no answer for, right? I mean, this is one of these areas in which it's very common for me to mention some of the Brazilian litigation, what I know about the Indian and other litigation to North American activists, and they're incredibly, it's hard for some of them because they go to too many conferences where they tell people how to do public impact litigation strategy. But the fact is that there's possibilities for litigation here that no longer existed in the United States based upon our current constitutional doctrines, right? So this is one of these areas where I think the South-South comparison should not simply be something for Southern consumption, but can be for Northern consumption as well. I think looking beyond this to my other area of interest, which is in China, which is even not a democratic regime, is an area where there's a great deal of actual use of the legal system to try to remedy the rights of sexual minorities and actually women to various degrees. And one of the interesting things about using the sort of comparative solidarity approach is that it allows you to engage with activists who are not simply using the law for convincing judges. So for example, last year, I befriended a Chinese LGBT activist, Joe Dan, who basically said, I go to court just for publicity, just to make people know that we exist and that we're discriminated against. And I have no hope that I'm going to convince a judge. So he says, part of the problem is, like, I go to conferences, everyone argues about how to reason to judges. It's nice, right? But ultimately, I want to be able to talk about how to build social coalitions, because that's the only way that change is going to happen in China, right? So when we talk about how different like these examples are in the South-South exchange, there are other examples that are even more different, but nonetheless, there are these ways of looking at the experience that we've had here in Brazil and India, and applying even to those regimes as well. So in the end, I just would offer that this idea of comparative solidarity or comparative empathy and how to coordinate legal and social strategies really could lead to something a little bit more specific than putting this all under the pale of, or the category of comparative constitutional law, and really comparative constitutional change or comparative constitutional activism, right, which I think is a large part of what's driving the interest in all these different examples. So again, thank you for having me.
Okay, I'm going to take, if there are questions, we have time for a few, or comments. One last question, if I can. Because you made the right point about China, and we could think about the next work, including China, like the BRICS thing and Russia. But I don't know, are there any comparative constitutional studies, including China and other southern countries? And I think for us, it's still very, very difficult to understand anything about China. And I would say that all our partners came through a northern relation. So we have a relation with a university in China, but it's because they are involved in public interest law litigation. Like, I feel we don't understand each other horizontally yet. Just to ask if you think, if there are works of horizontal comparison, and if you think it's possible, or we need a little bit more time. Oscar?
Yes, I'm sorry I was not here the whole time. You know, I have another job that I have to run. And
that's when I did my criticism of your history of comparative law. I waited till you were out of the room.
I'm glad I was not here. So, but I got your last point, which obviously made me very happy about the idea that this is not just about the South dialoguing horizontally and learning from each other's experience, but also this can present some very good insights for those who are dealing with constitutional litigation, strategic litigation in the North. Yes, in fact, this has been debated in our group several times, not just on the strategic or the doctrine that was being produced by both by the courts and the lawyers, but also some of aspects of institutional design, etc. So yes, I humbly say that there is a dialogue that should be implemented north-south also about this. Do you see, you don't have to answer this, opportunities, let's see, to launch this book in some meetings or conference or audience in US, and the same question goes to Sandra regarding Europe and Britain?
Taking advantage of having an anthropologist, I'd like to that you comment, like we have here a difficult interaction I see between rule of law and post-colonialism discussion or post-colonialism context, and that makes a very interesting scenario, or maybe it's like I don't know, with a particularity of the South, and makes everything more complex. I'm thinking about the recent example of Uganda. Then we have the question of the homosexuality being a crime, and all the debate about the Occidental values and the post-colonialism, rejection to the colonialism values. So I think this is also a very interesting issue, and that we can share. In some places, it's stronger than, for example, in Brazil, but maybe it's another issue that brings complexity to the South-South comparison.
All All right, those are all really great questions, and as an academic, usually that means it because it allows me to talk about things that are interesting to me. Well, I think I'm going to start with Marta's question because it also ties into what the discussions of customary law from before. There was a legal anthropologist named Martin Shannock, a British, who went to studied customary law in Africa for many years. And one of the things that he found was that these authoritarian sort of imaginations of what customary law were often creations, fabrications. Many of them coming from the records of colonialists and missionaries from centuries before, right? And one of the interesting ways in which this was picked up recently in countries that we haven't mentioned before is as Islamic countries, right? The interpretations of what traditional Islamic law has had a highly authoritarian, increasingly patriarchal bent, right, in many Islamist regimes, right? And study has shown that this often doesn't actually reflect the historical practice. But what it does reflect is that in these post-colonial, right, regimes, elites have an interest, right, in portraying the foreign as bad. Right? Now, that doesn't necessarily mean the foreign wasn't bad in a variety of contexts, right? But they do so to reinterpret the past to empower themselves relative to their own domestic constituencies. Okay? So this is one of these complexities in determining like what customary law is, right? What are our traditional values in post-colonial context is very different because this is one of the ways in which you generate solidarity, right? This is how you made the post-colonial revolution happen. Right, was by rejecting the foreign, right? But then what's the liability of that, right? When then you come to deal with these internal sort of discriminations, right? So in this class of like same-sex marriage, well, it's like now they do in the Ugandan case say like, the Westerners, right? Even though it's actually American evangelicals funding a lot of this movement in Uganda, foreigners love same-sex marriage, and we're doing this as an affirmation of African identity. Well, the truth is, if you look at most African countries, right, and you look at people who've done the history of sexuality in those and all the different and very, very diverse indigenous communities they had, sexuality wasn't the clear binary, right, of man and woman. There were all sorts of in-betweens for shamans and other people like that. So I think one of the interesting things is you see that this is developed as a strategic, right, development for people who are trying to use courts and rights language in different ways against these same types of ends. So I think it's one of those ways when you're doing these types of comparisons, right, even though you have these differences, you still see that ultimately you have to construct solidarity. And the way in which you construct solidarity on a political level and the legal arguments you make can't be divorced, right? Otherwise you get these unintended consequences. So for Oscar's point, the South-South-North, I think there is, I mean, this is, you're talking about my life story, right? And why am I teaching here? It's beginning, right? But there's so many issues in which there's heavy stagnation, right? I mean, so if you want to go into my own scholarship, countries like the United States love to export things when those things being exported are actually representatives of domestic losers in politics, right? So when people really wanted to export sort of forms of American like social litigation and activism, we're in a time when like the left in the US was actually not doing so well, right? So they turned to the international as an easy place to go to sell what they were selling because no one was buying it domestically, right? And so there was this cycle that would happen over time in the realm of economics. I think just now people are just getting to the point where they're just like, look, in some areas, like area of my interest, like labor organization, we have like no answers for anything moving forward, right? When it comes to this particular set of issues of like the rights of minorities and women, I think people are increasingly frustrated, right? And the truth is like, is Rome finally going to come to the rest of the world? I mean, I don't know, like empires don't end very well because people have a hard time letting go of these notions of superiority. So I think there's a possibility, and I think there are allies, but I think it's still like a long way before you can sort of get this type of comparative work accepted on a broader level, right? Where you could say, look what Brazil did with same-sex marriage, and people in the U.S. aren't going to, inherently say, well, then we shouldn't do that, right? That's still the reflex. So I think it's just how much you think the stark lack of answers to these problems is really going to push people to get past their historical and cultural biases. So talking about China, the interesting thing about China is the Chinese feel the same way about Brazil. They're like, we sell a lot of things to Brazilians. We buy a lot of stuff from Brazil, but we don't really know exactly what's going on, but we'd like to know more, but they just seem so different, right? I mean, this is this idea of like, how do people perceive and construct difference in this way? I think there are definitely linguistic barriers, right? The number of English people or Chinese people cross-referenced with Portuguese who share similar linguistic backgrounds is like even smaller than the ones that we're dealing with here, right? So doing cross-comparative research is really, really rare. I mean, most people do East Asian research and they do like Latin American research, and this is good horizontal research. A few people have done like China, India, right? This whole BRICS thing, which am I allowed to say I don't like? I mean, it's a popular organizing metaphor here, but because it's really in the infancy, because to really you can do some sort of like abstract statistical regressive type of analyses of different facts coming out of China and different facts coming out of Brazil, but if you want to do and compare the type of textured research qualitative that we're doing here, there just really isn't much, right? I hope to do some. I hope to do whatever I could do to foster some among people who have this interest, but the differences aren't as stark as you would think, right? It seems sort of insurmountable, but like as I just try to make this quick sort of example of Joe Don and his public impact litigation strategies, it's not completely dissimilar. All right, so the Ireland example. So I think the Ireland is a great example of the limits of formalism, right? And like earlier when he was giving his history, Oscar said, well, we had to get beyond natural law. Well, the truth is 90% of people live in a natural law universe when it comes to reasoning. That's like folk conceptions of law or natural law. And they're still very powerful, and especially countries that have strong religious backgrounds, right? I mean, natural law in an Islamist regime is what law is, right? And so I think the Irish the example puts that as well. But I think what it gets at then is what people have tried to branch out into in a variety of areas is expressive notions of law, right? Is it enough to say that we're formally equal in all these substantive ways, or what does the law say when it makes this discrimination, right? I mean, this is just the same thing going back to different stages of racial justice, right? Separate but equal, right, was the phrase in the United States, right? We can say everyone has the same schools, everyone has the same stuff, has the same rights under tax law, right? But is there some sort of expressive element? And actually, this is the point where the same-sex marriage activists in the US say, right, it's the expressive thing that we're all the same. That's actually why we don't want these judgments, because we're not all the same and we don't want to say this. And it's actually going to be a problem for substantive equality down the road. Right? And you've gotten so hung up on formal equality that now, once we get out of this phase, even if we win, our ability to organize around these other substantive issues is going to be compromised. So I think one of the interesting things then is, even if the Irish court, I know its interaction on issues like abortion with the European Court of Human Rights is an ongoing issue about how much it can sort of assert its particularity. Right, and this led to this idea of, like, again, it's formal versus, you can have the formal right to abortion, right? There's states in the United States where it's like, you have the right to abortion, but there's one clinic that you have to drive like a day to, and there's only one doctor who will do it. Is that a real right? Okay. So I think, I think one of the opportunities in looking at this, right, is this twofold. Again, like, how do you make arguments to a specific court, right? In this sense, sometimes you're limited, right? But I think you can't segregate that from your social strategies, because, like, okay, let's say we win that, right? And then we have all these formal rights. What then for, gender or sexual minority-based violence, right? What about these sort of other issues of discrimination and positive remediation? And I think all these things help contribute, because there's no one right answer in any particular context. I think that's the illusion, right, of comparative law in the earliest 20th centuries, that we'd find the one right answer and then you'd share it with everyone. I think the basis is that you have these types of stories, and from it, right, if portrayed honestly, you can extract the type of lessons that are most productive for your particular needs and context. And sorry, for the speaking fast, it's an old habit, so it's hard to break.
And it's the first time I have to ask for that without translators. It was for us. Thank you very much. Thank you all of you who were here listening. Thank you to our speakers. I think the next step is continue this discussion, having it on iPad and other materials, doing the launching in other universities, probably now in the north. And please share with us your comments. If you read the book, if you use it, my email is in Conectas website. You will find our emails easily. Share your comments with us. Even if you decide to do a book review, also share with us that we can publish it in the Sur Journal or in other magazines. So thank you very much.
Thank you.